Hey guys, welcome back to the Real Laura B. I am so excited that you came in, and I have a great guest today, Andrea Burkhart, that's going to help me go through the legalese that I have for this particular document. So stay tuned, and I'll be right with you. Hi, I'm Laura, also known as the Real Laura B from Twitter. I'm a researcher, truth seeker, and a new wave internet journalist. I'm not a lawyer, nor offering any legal advice. Join me on a journey to draw the curtain back to expose key news developments in the world of celebrity lawsuits and current events. Let's get started. Hey guys, thanks again for joining me. We're going to be going over this document, Johnny's answer to the claim. And I just want to let you know that I was kind of shocked to find out in the last day or two that I am now monetized. So I think these super chats kick in somehow. If they do, they do. If they don't, I'll do the best I can to get your questions. But what I want to do is now bring in Andrea Burkhart.
There she is. Good morning.
I am so excited you're here. We go way back.
Yes, we do. Yes, we do. Laura is like the queen of the archive. When I was first starting to get into the Johnny Depp case, I was really kind of publicly starting to pay attention right around the time of the UK trial. And so Laura was just a gem of a resource for all of the background information and context and any questions I had. She's there to fill it in. So thank you, Laura, for everything you've done to really bring this case out into the public.
And having said that, Andrea is one of my great resources. When I get a document, I can Google a lot. A lot of Depp team is really great at writing. I don't know what you would call it, just normal people English in their motions, so I can understand them more. Where plain language with the language a little bit out there, a lot of legalese. So I remember several times saying, "Hey, what does this mean? Am I getting this right?" And this was one of the documents that I know people will have a lot of questions on. So I wanted you to help me with, and I really appreciate it. So maybe you can still tell everybody. I think most of them know who you are based on the chats, but maybe you can give me an idea what you do and in general.
So I'm a practicing attorney. I'm licensed in the state of Washington. I've been an attorney since 2007. So quite a few years. My primary focus is in criminal defense. And so I have done a whole bunch of trial work, a whole bunch of appeals, but I have done civil litigation as well. So that's kind of my background and what I bring to this type of analysis. I'm here.
Okay, great. Well, they're saying I have to enable. Yeah, they said I have to enable the super chats. And as far as I know, I did. So I'm not sure what more I have to do. So it may not work on this one, but I've gone through everything I'm supposed to go through, and it says it's enabled. So automatically for live chats. So I don't know. I'm not worried about it. So let's start into this, and then I'll kind of follow some of the questions. So let me share this. And I've sent this ahead of you so you can help us. I think the first thing well, let me show you this first before we go too far. Let's go into the claim. So the claim was filed way back July 6, 2018, and he did then file a lot of dismissals. So he's excused everybody from the claim except for Johnny Depp and his production company. Oh, it's working. Thank you. I'll put that right up. There it is. It's working. Yay. And thank you for the super sticker. Okay, so we know it's working. Anyway, he's dismissed everybody except himself, Johnny, and the production company. And he's dismissed a lot of the complaint for damages, leaving just for Johnny assault and battery, intentional infliction of emotional distress, negligence, and negligent infliction of emotional distress. Now, do you think the negligence is in there for Johnny, or specifically that's why he's holding on to Johnny's company?
Yeah, that's a good question. I suspect it could be the last little residual piece of Johnny's company, that he's arguing some type of theory that, oh, they should have known that, Johnny's a wild card and would cause problems on set or something like that. So it's kind of a negligent hiring, negligent retention type of theory.
Okay. Yeah. I was thinking, like you said, insurance, maybe his company could have insurance kick in. But again, this is assuming the guy's going to win. We don't know that he's going to win anything.
Of course.
Right. So, yeah, so it looks like things are working, and I'm amazed and thrilled. And I know Andrew's time is really limited, and we're going to see how much we can get her to cover some stuff. So I'm going to move a bit forward. And I'm looking for his answer. So the complaint's been filed. I have to take this off, and I don't know how to do this. The complaint's been filed, and he has to answer it, right? He has so many days to answer it. Otherwise, it's going to go into fault. So this is Johnny's answer. At this point, when he answered it, he still thinks there's certain people still a part of this claim. So,
yeah, and also a whole bunch of the claims that got dismissed as well. They dealt with basically employment liability types of issues because he was essentially trying to sue the producers, the director, the people involved in movie making. On these grounds that they retaliated against him, wrongfully and just otherwise, engaged in illegal employment related conduct. So all of that has since been dismissed. And as a result, there are quite a few of the defenses that he's raised that are really not going to be applicable at this point because they're really specifically addressing those claims.
right. And Johnny's
So
company, his
we'll get into
production
the
company,
details.
wasn't the one that, his company was the one that hired people. So he wouldn't be part of that. So defendants John C. Depp and individual defendant Depp and Infinitum Nihil, a California corporation, collectively answering defendants, hereby answer the complaint. And I'll tell you right now, this is what set me off when Deadline, and this is one of the reasons why I get these documents. Deadline came out, and a bunch of legacy media, as we call them, came out with these headlines. Johnny Depp is claiming self-defense, but not denying he hit him. And here we go in the very first paragraph. Pursuant to California code, answering defendants deny generally and specifically each and every allegation of the complaint and deny that plaintiff is entitled to any relief. Answering defendants further deny that plaintiffs suffer damages as a result of the alleged wrongful conduct of answering defendants, and further generally and specifically deny that the plaintiff is entitled to any remedy or relief, legal, equitable, or otherwise, in any sum whatsoever as against answering defendants. There it is. He's denying it. And yet the mainstream media would not produce that.
Yeah,
and this answer
it's one of those things that people who aren't necessarily super informed about the law, but maybe have a narrative that they want to pitch, can find something to craft a story that they want to get out there. The thing about this type of a document that people need to understand is that just because he is raising certain defenses does not mean he is actually going to argue them. This is a lot like the exhibit list for trial was that they filed in Fairfax County. It doesn't mean that all of that stuff is going to go in. It means that they have to raise it if they want to reserve the right to be able to argue it later. And so you file an answer at the very beginning of a lawsuit before you've had any type of discovery. You don't know what the evidence is ultimately going to come out to be able to show. So if you have any type of theory that you think, might be supported by, some version of the facts that comes out, then you really do have to raise it at this point. And that means a lot of these answers can sometimes be inconsistent. It means they can be alternative things. A lot of them, no, they wouldn't coexist. You wouldn't prove, both self-defense and that, Rocky Brooks entirely, did everything himself. So it's just reserving the right to be able to raise it depending on what discovery ultimately produces as evidence.
Right. And Steve is saying Rocky was fired due to his hot temper, does not suing others keep that reason out. Well, we'll be finding that out in discovery, but I think that has a lot to do with why he dropped good films. But we'll be getting to that. So the first affirmative defense is, again, what you just explained. I think we just go to the first one. The complaint and each cause of action alleged herein fails to state facts sufficient to constitute a cause of action against Johnny Depp and his production company. So that's just
this is basically just a legal defense. And it's one that If he is going to raise this, chances are it would be raised pre-trial. It's an argument that basically, even if you took all the facts that he had in his complaint as true, they wouldn't be legally actionable. So it's very likely that may have played into some of these dismissals. That
Right.
his allegations probably didn't actually support the legal relief that he's asking for. But these very basic claims of, oh, there was an assault and things like that, those are really factual issues. If those allegations were found to be true, then yes, that would be actionable. So we're probably not going to see anything further on this at this point. But again, it's something that he had to raise early on, and it may have influenced what happened with those employment law claims.
I'm sure. Yeah. And a lot of them, they didn't answer. The only answer that's up is Johnny's. So there must have been a meet and confer behind the scenes with these attorneys for these other ones that said, yeah, you don't have a case. You just need to drop it. Because there was no official motions filed by the other defendants. In fact, I don't think Furman ever got served. I think it all happened behind the scenes. Second affirmative defense, plaintiff's claims are barred by the doctrine of self-defense or defense of others. And this is another thing the mainstream media didn't report. They just said self-defense. They left off the defense of others, which is very much what Johnny's claiming in this case.
Yeah. And I think part of too what can be confusing about this type of defense, because we don't know factually what they might be relying on to assert this, right? And so a battery is any physical contact that is potentially offensive or harmful to the other person. So it doesn't have to be, a full on, like, he cracked him or something like that. It can literally be like putting your hands on somebody and moving them. So pretty much any type of physical contact has the potential to open up a door for an argument that there was some type of battery involved. And so the reason I bring this up is because what we know factually about this altercation, from Johnny's side, is that, Mr. Brooks was berating this homeless woman and Johnny Depp intervened. And so we don't know if it's possible. Did he, step in front of him? Did he maybe, put his hand on him in any way at all, just as a process of trying to separate him from that woman? So there's a range of possibilities there that, again, because this is pre-discovery, we don't know what Mr. Brooks is going to say, what his witnesses are going to say. If they're going to say there was some type of, even minimal physical contact, then they want to have the ability to be able to argue that that was reasonable because he was, threatening this woman and Johnny was intervening.
Right. And does that threat go to verbal too, or at this point it's only physical?
Well, at this point, I think it has to be only physical. Typically, you don't get to use physical force in response to words. So self-defense basically is the idea that if you are threatened with physical force, you have the right to use proportionate, reasonable force in response to prevent yourself or somebody else from getting hurt. And so since words can't hurt you, physically speaking, typically you're not able to use physical force on somebody based on language.
Gotcha. Third affirmative defense, plaintiff provoked the alleged altercation. The acts complained of by Rocky were provoked by Rocky's unlawful and wrongful conduct, in that Rocky willfully and maliciously acted out and conducted his activities in such a manner as to cause Depp to fear for his safety. And according to Depp's observation, defendant Brad Furman, who's no longer defendant, to fear for his safety. So now we know Brad was around. Mm-hmm. Rocky is therefore not entitled to an award of punitive damages.
Mm-hmm. So this is a very interesting.
We know punitive is extra money.
Yeah. This is a very interesting affirmative defense to me, because this comes out of the common law. And so this is something that we see in criminal cases. I don't know exactly how it applies in a civil case. I guess it would take away the punitive damages, if any. But so the idea is that provocation, this is where words potentially can mitigate liability. And the idea is that the words are so egregious, or the conduct, the provocation is so egregious that any reasonable person would lose it, or get so
Right,
angry
right,
you just lose it. That's
right.
kind of the argument here. And so in the criminal context, the idea is that negates your intent to act with a specific purpose. You are just acting in the heat of passion, so to speak. So where it's most commonly seen is if somebody is charged with murder and they argue, that person provoked me so badly, I responded, and obviously, wasn't great. But so the idea is that then becomes a manslaughter rather than a murder, because they acted out of the heat of passion rather than with intent.
Okay. So fourth affirmative defense, contributory negligence. The complaint and each of its causes of action are barred and recovery reduced to Rocky's own carelessness, recklessness, and or negligence in the matters complained of in the complaint. The damages referred to in the complaint by plaintiff are approximately caused by the Rocky and or affiliated in any manner with Rocky, and that all times relevant herein, Rocky failed to exercise his own protection, the proper care and precautions which a prudent person under the same and similar circumstances would have exercised, and that if these answering defendants, which is just Johnny, committed any wrongful act, which is not admitted herein, the conduct of Rocky and other contributed to the happenings of Rocky's alleged damages. Whoa.
So this is the idea that in a negligence type of situation, you don't always have one person is obviously 100% at fault, one person is 0% at fault, right? And so they can both contribute to something bad happening. And an example of this might be, okay, we're in a car accident, and maybe I fail to yield to somebody who is, making a turn in front of me, and so they turn in front of me, they have the right of way, and I blow the red light or something and hit them. I'm obviously negligent for doing that because I didn't abide by the traffic signal. But let's say that person is not wearing their seatbelt, and so when I hit them, they get ejected from the car and end up in a coma. Well, them not wearing a seatbelt is their own negligence.
Okay.
I'm not necessarily responsible for the consequences of that. So contributory negligence is just this idea that the jury needs to sort out kind of what percentage of the harm is each side responsible for. So it's basically saying Mr. Brooks is not faultless here. Therefore, some portion, if he gets any damages, any liability at all, needs to be offset by his own fault in either bringing the situation about or, causing the damages that occurred.
So he was screaming at this poor woman. He should have expected that somebody might step in and stand up for her. Yeah?
Yeah.
Plaintiff's own actions caused injury. If Rocky sustained any loss, injury, damage, or detriment, collectively damage, as alleged in the complaint, the damage was caused and contributed by his actions, in that he did not exercise ordinary care in the performance of his duties at the time and places alleged. Thus, Rocky's own actions and omissions proximately caused and contributed to his alleged damage, if any, and the recovery, if any, should be at a minimum, be reduced in proportion to his fault.
And so this
his
is
actions
basically...
We're on a delay. You go ahead.
Oh, so this is basically it's a similar argument, a similar defense as the last one, the contributory negligence. But what this one is getting more at is causation. Anytime you file a tort claim, a personal injury type of action, part of what you're going to have to prove is that the other person's fault caused you to suffer some kind of injury. And so this is just basically arguing, hey, look, even if we didn't act perfectly in this situation, we're not the ones who caused it. You're the ones who caused it by, instigating this altercation and so forth.
Yeah. Proportionate of damages. If plaintiff suffered or sustained, again, Rocky, any damage as alleged, and I'm saying Rocky because we just came out of this Fairfax trial. I don't want people to get confused between plaintiff and Johnny. That can be easily be done. If Rocky suffered or sustained any damage as alleged, those damages were approximately caused and contributed by persons or entities other than these answering defendants, which is Johnny, including but not limited to the unnamed defendants. There's a Joe's through 1 through 50. I guess that's possibly during discovery that they found anybody else involved. Any liability of defendants named and unnamed should be apportioned according to the respective and relative degree of fault, and the liability of these answering defendants, if any, should be reduced accordingly.
Yeah, so again, this is similar to the fourth affirmative defense, the contributory negligence. The difference is just that contributory negligence is just between the parties. You know, you're 50, I'm 50, therefore the damage is offset. The sixth affirmative defense is somebody else was responsible. Somebody who's not part of this lawsuit had some fault in it as well. And so their liability also needs to be accounted for when the jury is deciding, you know, who ultimately needs to pay what, how all the responsibility kind of breaks down between everybody who was involved.
I find this interesting because, so what Johnny is saying is, hey, before you even got to me, there may have been other people that contributed to your bad behavior. And we kind of find out there was.
Yeah.
Spoiler. Seventh affirmative defense, failure to mitigate. Plaintiff failed to take necessary and prudent steps and measures to mitigate the damages he alleges and has thereby solely and proximately caused to himself the damages, if any, alleged.
Yeah, and so this is the idea that you don't get to just lay back and say, poor me, I've been suffered, and not take any sort of responsibility to heal yourself, so to speak.
Right.
Basically, the idea is that the wrongdoer is going to be responsible for causing harm, but that harm is kind of constrained by what would a reasonable person do to avoid things, you know, being worse.
Right.
Failing to get medical treatment is kind of a good example. You know, again, you get in a car accident, maybe you're injured, you don't go to a doctor,
Right.
but then, you know, 2 years down the road, things have gotten worse, and you've gotten, you know, you've had to have more surgery, more treatment, something like that, because you didn't deal with it initially. That's the type of situation where a plaintiff or a defendant may be able to argue, look, you know, a reasonable person would have gone and gotten medically checked out up front, and then this would have been dealt with ahead of time. But instead you know, chose not to do that. And so your damages were worse because of your own unreasonable decision not to try to fix it.
Like maybe you should have even taken an Advil.
Well,
more to come.
Yeah. And I feel like in this situation, this one may relate a little bit more to the employment law claims as well, because a lot of times in that situation, what you're talking about is, okay, I was wrongfully fired and now I can't get a job. But did you try? You know, what did you do to try to go and get a replacement position, you know, so that you didn't lose, you know, a whole year's worth of wages. You don't get to sit back and take a year's vacation and then say, oh, it's his fault because he fired me. You have a duty to try to, you know, get a substitute for what it is that you lost in that situation.
Yeah. Pamela, I'm going to get to your question. It's just more specific and outside of what we're talking about right now, but I have not forgotten you. Assumption of risk. At all times mentioned, Rocky knew the risk involved in his actions and conduct and full knowledge of such risks and appreciating the dangers thereof. Nevertheless, voluntarily assumed such risks that by reason of the premises, Rocky is barred from recovery herein.
So this is real similar to, like, if you go and you run a 5K and they will have you sign a document at the very beginning. There's usually several things in those documents, and one of those is advising you. Running is a risky activity. You can trip, you can fall, there might be cracks in the sidewalk, there might be other people who would bump into you. There are just known risks that go along with engaging in this type of activity. And so it's a way of advising you and getting you to kind of sign off that, yes, by choosing to participate, I understand that these risks exist and I am voluntarily choosing to encounter them. So then that makes it not unreasonable on the part of the defendant that
There's
you
a
were
limitation.
exposed to that risk.
Okay, the next one was statute of limitations. The complaint and each cause of action alleged therein is barred by applicable statutes of limitation. Now, I have not seen them file anything regarding this. This is early on, but I haven't seen that.
Yeah, and this
We
one
did see
as
that with
well,
like
they
Amber's
would,
Demore.
yeah, they would deal with this pre-trial if it were going to come up. I don't think because the alleged actions took place in April of 2017 and his lawsuit was filed in July of 2018, the overwhelming majority of claims, like personal injury claims in California, have a 2-year statute of limitations. So probably, that's not going to be something that we see. I don't know the details of the other like employment related ones though, and whether those, if they had a 1 year, basically anything had a 1 year statute of limitations, that could have been a basis to try to get it kicked.
Avoidable consequences. These answering defendants, which is Johnny, alleges that because Rocky failed to take all precautionary steps at his command, Rocky's damages, if any, cannot be imputed to those all the answering defendants, obviously, but it's just Johnny left, under the doctrine of avoidable consequences, thus barring in whole or in part plaintiff's recovery herein.
So this one, I believe, is also specific to the employment law claims. And the reason why is because this doctrine of avoidable consequences in California is specifically dealing with claims of a supervisor sexually harassing employees. And basically what the doctrine says is that if the company has like a policy for being able to respond or report and get protection, and you don't use those tools available, then you could have potentially avoided the adverse consequences that you suffered. And so basically it's a way of holding an employer not liable for something that a supervisor does under those circumstances. It's basically an open question under California law if the court would apply this doctrine to a different context, whether outside of employment or to claims other than specifically sexual harassment. So that's my suspicion, is that this was dealing with an employment claim. It's not a sexual harassment claim. It's more of a retaliation or something like that. But just trying to take advantage of this gap in the law to say, look, it's not sexual harassment, but we had policies or procedures available to be able to report problems with supervisors, working conditions, things like that. He didn't take advantage of them.
Waiver. Rocky's own actions and course of conduct constitute a waiver of his complaint and allegations contained therein.
Yeah, this one as well. This is going back to the thing that you signed for the 5K, where one of the other things that's going to be in that document is that you give up your right to make any claim against the promoters because you suffer, something as a result of ordinary negligence. Typically, you can't waive gross negligence or, reckless conduct or things like that. But for things that are just simple negligence, you can waive your right to be able to argue that. So it doesn't have to be something in writing. It can be inferred through a course of conduct. But the idea is just basically he gave up his right to make any type of claims against these individuals.
Yeah. In pari delicto. Is that right?
In pari delicto.
The answering defendant, which is now just Johnny and his production company, are informed and believed and therein allege that each and every purported cause of action contained in the complaint is barred because Rocky has engaged in acts and courses of conduct which rendered him in pari delicto.
So great legal Latin here. In pari delicto means equally at fault. And so this is a doctrine that basically said you were a wrongdoer here as well. And so under those circumstances, and we'll see that in some of these other some of these other affirmative defenses as well, there's basically a policy idea that you don't get to profit from your own wrongdoing.
Right.
If you're the one who caused the problem, even if somebody else also caused harm, you don't get to take advantage of the fact that you yourself engaged in illegal or wrongful conduct to collect from that person.
Yeah. Intervening or supervening cause. The answering defendants, Johnny and his company, that's all that's left, alleged that any damages suffered by Rocky, which damages are expressly denied, were approximately caused by the intervening and superseding acts of Rocky and or others, which acts bar and or diminish plaintiff's recovery from these answering defendants in whole or in part.
Yeah, so again, one of the basic things that a tort claimant always has to prove is that the damages that they're claiming were caused by the wrongful conduct and not by something else. And so in tort law, it requires what's called proximate cause, meaning that it's not just but for this thing happening, you suffered the injury. It means it is the most recent thing in the sequence of events that resulted in your injury. And so what essentially they're arguing here is that even if we caused you some type of damage, there were intervening causes, things that contributed to the damages that you claim that you suffered above and beyond and after anything that we did that may have caused damage as well.
Consent by plaintiff. Rocky agreed to and participated in those actions which Rocky claims to have caused injury or damage. Since such participation and consent were given knowingly and voluntarily, Rocky's claims are invalid.
And so with this one, lack of consent is an essential element that he has to prove for both assault and battery. And so this is just basically saying he's not going to be able to prove that element.
Yeah. No employment relationship, and this for sure applies to Johnny. Rocky was not an employee of either of these answering defendants, as he was an independent contractor, and as such, Rocky's complaint fails to state facts sufficient to constitute any cause of action against these defendants, and Rocky is not entitled to any recovery. And that is confirmed that he is hired from an agency to do this work. So Good Films doesn't pay him, somebody else does.
Yeah, and this one as well, I think given the causes of action that have survived at this point, this is really not going to be applicable. None of his remaining claims require or really depend on any type of employment relationship that he himself has with any of these parties. So this one I think is moot at this point.
Probably this one too, at-will employment. Yeah. If the plaintiff is found to be an employee of either of these answering defendants, although such is not admitted herein, plaintiff's employment was terminable at will of either party under California labor law. Plaintiff has no claim to cause of action based upon claim termination. And we all heard that he went up and he was fired. What we haven't heard is why he was fired. And I think that'll come out later.
Yeah.
Should I keep going? Willful breach of duty. If Rocky is found to be an employee of either of these answering defendants, although such is not admitted herein, Rocky willfully breached his duty pursuant to the labor code, and obedience was neither impossible nor lawful. And again, I don't think this applies to Johnny and his company.
Yep.
Equitable estoppel. Boy, we heard that word before, haven't we? Or those words.
Estoppel, yes.
Rocky is estopped by his own actions and course of conduct from pursuing his unverified complaint and each purported cause of action contained therein in violation of, among others, California labor codes.
So this one, I believe, is also, again, it's going to be related to the employment claims, because where it specifically gets used in California is when somebody is hired for a position and it's their own lack of skill or training or knowledge that causes the problem. And so with this one, for example, if he messed up with the permitting or something like that because he doesn't know how to do his job, he doesn't get to hold Johnny accountable for that. So again, I don't think this
Yeah.
probably relates to the surviving claims, but it is just a sort of fun argument to look at.
Especially when we find out. Yeah, especially when we find out later on what Rocky did. If plaintiff is found, or abandonment of duty, if Rocky is found to be an employee of either of these defendants, although such is not admitted herein, Rocky did not substantially comply with the directions of his employer, and any alleged damage to Rocky is the result of his willful abandonment and or neglect of his duties, and or his unexcused inability to perform his duties in violation of California labor law. And that again would apply to good films who fired him.
Yeah.
Failure to state facts to support punitive damages. Rocky has failed to plead facts sufficient to support allegations of oppression, fraud, or malice under California Civil Code. Against these answering defendants, Johnny and his company, Rocky's complaint does not state facts sufficient to enable Rocky to recover exemplary or punitive damages against these all defendants.
And so in California, in order to get punitive damages, you have to show a couple of things. One, you have to establish there's a breach of a legal obligation that is not just something that arose from a contract. You presumptively do not get punitive damages for a breach of a contract. So it has to be some other type of obligation arising from law. And that's often, regulatory requirements. In this particular case, likely labor rules and things like that. So you have to show both that there's this outstanding legal obligation that was breached, but then you also have to show that they acted with oppression, fraud, or malice. And so those have to be typically specifically pleaded in the complaint in order to support that going forward. And he's just basically arguing, they haven't established the necessary requirements to be able to make this type of claim. Again, I think it may have made more sense when he was arguing, these various labor violations and stuff. All he's got left now are just basic common law tort claims. So they're, presumably not going to
right.
Give rise to this type of obligation anyway.
Okay. Unclean hands. Rocky's complaint is barred by the doctrine of unclean hands by reason of Rocky's own actions and course of conduct.
And this is similar to the in pari delicto argument. Just basically the idea is that if you are a wrongdoer, you don't get to come to the court and get rewarded for that. You have to come to the court with clean hands. You didn't contribute to the wrong or the harm that resulted.
Yeah. We can probably skip this one. And if there's any other one you want me to skip because the defendants are gone, workman's compensation doesn't affect Johnny, right?
Yeah, that workman's compensation doesn't affect Johnny. The covenant of good faith and duty of loyalty is not going to affect Johnny at this point. That's dealing specifically with obligations of an employer. The good faith also, the argument being that, whatever employment actions they took, they did that reasonably and not arbitrarily. So that's not going to apply anymore. Duty to mitigate harm. In this particular context, it's the same essentially as the argument that they raised in the 7th affirmative defense. So this one is just dealing specifically, I think, with what California looks for in the employment context. The 26th, the after acquired evidence is dealing with the employment relationship, arguing, even if we weren't justified at the time, if he did some stuff that we discovered after the fact would have justified it.
You're garbled for me, but there you are. Now you're back. I lost you for a minute.
Oh.
So duty to mitigate harm, I guess that's also like I read in the prior claim that they were trying to say all of these defendants, which I guess could be his production company, should have known that this plaintiff, that this defendant, Johnny Depp, may have not been a good employee, but I don't think it applies to his production company here.
Yeah, well, and so this one of the things that I looked at when I was looking through these affirmative defenses to try to sort them out is California, like many states, has pattern jury instructions. And so they have different jury instructions that lay out what are you going to have to prove to establish these affirmative defenses in different contexts. And so that's why I think we see some overlap between, this right here, duty to mitigate harm, the 25th affirmative defense is extremely similar to the 7th affirmative defense of failure to mitigate. And the reason why is because I think they pulled the 7th affirmative defense from the defenses to just regular torts, ordinary negligence, and this 25th one they pulled specifically from the employment law ones. So they're extremely similar doctrines. It's just that the way that those specifically get worded in the jury instructions are a little bit different. So they have covered all their bases by using both.
Yeah. Again, if after acquired evidence, if plaintiff is found, Rocky's found to be an employee of either, which would not apply to Johnny, right?
Yes, that would not apply to Johnny.
Performance of duties. These answering defendants, meaning just Johnny, and each of them fully performed any and all contractual, statutory, and other duties they owed to Rocky, if any, under applicable law. Rocky's complaint and each cause of action set forth are barred.
Yeah, and this one as well, I think it's just dealing with the employment claims, because your only real obligation outside of a contractual relationship is to act with reasonable care.
Right.
And so this is dealing, I think, specifically with if they had been an employer, they would have additional statutory duties, fiduciary duties, things like that. So those are no longer going to be applicable.
In his claim, he did ask for relief for his attorney's fees. Rocky's complaint is without merit, and these Johnny Depp are entitled to recover their attorney's fees, costs, and other expenses occurred in that Rocky's complaint has no reasonable basis supporting the claim set forth and is brought solely for the purpose of harassment and obtaining improper payment to Rocky. So yeah, Johnny wants to be paid for the costs.
Yeah, so this derives from a portion of the California Code of Civil Procedure. It's section 128.5, and it authorizes essentially fees, costs, and possibly punitive damages as well for filing a frivolous claim. And so a frivolous claim is basically one that has no arguable merit in fact or law and is brought for an improper purpose, since basically it's not going to be justified on the evidence and under the law that your reason for doing it was to harass somebody, to intimidate them, to try to extort them, something along those lines. So that's essentially what he is alleging here. It is a very high bar to clear with frivolous because they will not assume that just because somebody loses a lawsuit that therefore the lawsuit was frivolous. Somebody is always going to lose, anytime a case gets tried. So it really is more of a standard that nobody could look at this situation and think that legal relief is entitled here. I don't think it's probably going to clear that bar just because they're going to look at it from the standpoint of if what Rocky Brooks said was true, hypothetically, if a jury bought it, would that justify relief? And the answer is yes, it would. We just know, because we know the context, how extremely improbable it is that anybody is going to think Rocky Brooks was telling the truth about this altercation.
So this frivolous lawsuit, is this a motion that Depp would file separately, or is this just automatically just thrown in there now with his answer?
So it's typically going to come up separately. This is another one that could have factored into the employment law claims, because again, just if they can't establish an employment relationship in the first place, and they can show that Rocky would have known from the very beginning that he wasn't an employee of any of these people, he was an independent contractor with this other organization, and so on and so forth, then that is the type of thing that might give them a decent argument that, you know, this was total crap. And so it gives them leverage to potentially get that voluntary dismissal, because they're like, look, we're just going to move to dismiss it, or we're going to move for summary judgment, and we're going to ask for these claims because, you know, they never should have been brought up in the first place. He can also bring this up at the conclusion of the case once it goes through trial and gets a verdict,
Okay.
depending on what comes out. If it looks pretty overwhelming that, yeah, this guy completely made all this stuff up, there's overwhelming evidence against him, nobody substantiates his version of events, then that's a pretty, you know, pretty stronger basis to argue that he did not have a reasonable factual basis, and he should have known that.
Right. No violation of plaintiff's rights. Johnny Depp alleges that at all relevant times, they acted in good faith and good cause toward Rocky. Johnny Depp's conduct was within the reasonable expectations of the parties and was reasonably related to the legitimate business interest of all these defendants. It's just Johnny did not directly or indirectly perform or fail to perform any act that would constitute a violation of the rights, if any, of Rocky. Rocky's not entitled to any damages whatsoever.
This one is also getting at the employment stuff and the idea that he has rights as an employee, and so therefore, you know, whatever they did, you know, he has to allege that they violated that. They're saying no, they didn't.
And as an employee, this wouldn't apply to Johnny.
Yeah, correct.
Again, as an employee.
Mm-hmm.
That's good. Did not violate fundamental and substantial public policy. That sounds like employee.
Yeah, this is getting at the employee stuff and the idea that I think going to the retaliation claim that there are certain, you know, ideas that you don't get to restrict. You don't get to retaliate against people for doing things that they have a right to do. That would be against public policy, and so it's just going to that claim.
Yeah, causation. Each cause of action set forth in the complaint and the claim for recovery of damages, if any, are barred either in whole or in part because the actions of Johnny Depp did not cause or harm damage the plaintiff.
Yeah, and again, this is just because causation is an element that has to be shown for all torts. And so he's previously argued there may have been an intervening cause that you know, made you damaged, like maybe you're crazy, maybe that's your problem. That caused your damages.
Yeah.
This one is basically saying, you know, whatever I did didn't cause you any harm at all. So it's basically entirely on you or some other circumstance.
Yeah, Rocky was not retaliated against for any reason. Now, one of the things he was claiming in the future was Depp team was somehow blacklisting him.
Yeah.
That's going to be interesting for him to prove.
Well, and I think that one is probably out because without the employment claims and the argument for wrongful retaliation, the only real claim that he could have for that type of conduct would be something like a tortious interference with business expectancy. The idea that you know, somebody is trying to legitimately engage in work, and you are interfering with that. You're going to the person they're trying to work with, and you know, dissuading them from doing that. So there are that type of blacklisting activity that could be actionable, but he hasn't pleaded that. Those aren't any of his claims that he's making. So right. I think this is just going specifically again to that employment claim, and it won't factor into the trial.
Yeah. Rocky, in each cause of action alleged is barred by virtue of the fact that damages complained by Rocky, if any, are the direct and proximate result of the acts and omissions of Rocky. Thus, Rocky's recovery, if any, from these defendants, which is Johnny, must be eliminated or reduced in proportion to the amount of the conduct attributable to Rocky.
Yeah, and so this one, again, this is very much similar to the fifth affirmative defense that plaintiff's own actions caused injury. I think this is just the one pulled out of the employment law jury instructions. The fifth was pulled out of the general negligence jury instructions. More or less the same thing, just slightly different words.
Yeah. And the next one is pretty much the same thing, plaintiff's misconduct.
Yeah.
Right. His wrongful act or his misconduct.
And this one I think is
justification.
going to if they did, if he was an employee and if they fired him, it was justified because he engaged in misconduct. You get to fire people for misconduct.
Yeah. Justification, that goes to employment.
Yeah, I think that one also. So justification, I'm not entirely sure what this is talking about because justification itself is a very broad idea. Justification defenses do, generally speaking, include things like self-defense, defense of others, defense of property. These are situations where you're basically acknowledging, yeah, I did something, but it was legally okay under these particular circumstances. So I think because he has specifically pleaded the self-defense and defense of others already, that this one is not dealing with assault and battery. It's just basically dealing again with alleged employment actions and argument that, again, if they fired him, it was justified.
And again, it goes back to the Rocky's underlying conduct again.
Yeah.
Right to amend. He's not stuck he can add to these if something comes out in discovery or another defendant is found, or right.
Yes.
So Johnny Depp praised the following: the plaintiff will take nothing, that's Rocky, will take nothing by his complaint, and the judgment be entered in favor of Johnny Depp and his production company. And Johnny wants costs of the suit and the attorney's fees, and for such other and further relief as the court may deem just and proper. And this was by Randall Smith. We're going to see him. He's also partnered out there with Camille Vasquez and Samuel Moniz. Although we will see later that Ben Chu does join the team here too. Just for an update. And that's pretty much it. Well, we have a few questions if you don't mind, Andrea, and then we'll see. It looks like we're right at your time. So we have this one's kind of like a spoiler from Pamela. The declaration I read from script supervisor that she witnessed everything and photographed it all with timestamps and states no one physically touched each other, only words in the correct. Now, we have a lot of this case that's already played out in the media. I'm trying to catch everybody up with the behind the scenes legal stuff. And yeah, we know that Emma Demkoff already gave her declaration. She is a script supervisor. Her job is to take minutia photographs. So when people stop and say, hey, we're going to reset this scene, or I need to go to the bathroom, or you didn't do that, or maybe we're going to change the script a little bit here. She needs to make sure when everybody's back in position that everybody's tie is in the exact same place it was, the same angle, whether it was knotted or it was loose. Were you holding a coffee cup? Did you have a pen behind your ear? Anything like that. So she's really detail oriented about what her photos are. So for her to be snapping photos, even though it's not video, snapping photos through this whole thing, I think she's a great witness. And I don't see any other super chats. That's awesome. Getting to the bottom. Steve Cass, Amber has pledged his fees to her team. I don't know what that is. I don't know. I think Johnny will pay his legal fees. I don't think he has money to pay Johnny's legal fees. Tough. He shouldn't have brought I know we talk about this judgment proof all the time.
Yeah. Well, and that is one of the reasons too why people will often go for this punitive damages request. Again, it's a high bar to be able to clear, but punitive damages are much harder to wipe out in a bankruptcy than just ordinary tort damages would be. So,
is there any evidence? Well, we know Dana has her photographs. Evidence includes witnesses, right? So they're each calling witnesses.
Testimony is evidence. It may not be good evidence, but it is evidence. Right. So there is these scintilla there that he needs to be able to get to trial just by virtue of him saying, this is what happened.
Right. Because legally he can claim that. It's up for the jury to be the fact finders whether that happened or not, right?
Yes.
Right.
Yes. And they'll
So
do that by
this has been,
evaluating his credibility and his consistency with the other evidence, the other witnesses, and all those types of factors.
yeah, this has not been updated since October 2018. So they did in December a little bit. Yeah, they were supposed to go to trial. I don't know, we just blinked. For whatever reason, it got postponed. We don't know. I don't think it was COVID. COVID didn't really come out until December of 2018. I think what happened is there were some liminees filed, and the last one, which we'll eventually get into, threw a wrench to the judge. And she said, you know what? I can't decide this in a week. I need more information. And I'm just on my own account, I'm going to reschedule this. So that, and then pretty much everything stopped from December 2018 onwards, except for postponals, or a lawyer left, or a lawyer came on, or more postponals, more reasons to postpone, things like that.
From what I've heard, the California courts in general are extremely backed up when it comes to civil trials. And civil trials in general take lower priority than criminal trials. The reason being that criminal defendants have a constitutional right to a speedy trial. Civil litigants do not. And so it can often be the case that if you hit kind of a, you get your system gets a little clogged because you've got like multiple big trials or things like that going on. Very common for the civil case to get kicked in favor of other things that need to go forward. So things like that are very much a possibility. Sometimes people just get cold feet going into trial. They're like, oh no, it's going to be in a week. It's going to be in 2 weeks. I'm not ready. And they'll voluntarily agree to continue it. That's not out of the realm of possibility either. So without seeing something, we would be speculating about what caused it. But those types of issues are fairly common.
Yeah, if something gets uploaded, I'll definitely be covering it. I'm sure other people will. You're right. I have to watch out for certain words. I forgot about that. Hopefully we're far enough into this live stream that's not going to be picked up. I'm kind of skipping. We're having a great discussion amongst you all. I'm thrilled for that. I'm going to stick to this. It's filed in 2018. During that time, he was dealing with the backlash from the op-ed, plus the beer virus caused delays. Yeah, they didn't cause the first delay, but they did cause all the future ones. Mm-hmm.
Yeah, I think this is such a good point because this he jumped on this and filed this right in that time frame when the bad press that stemmed in many ways from the Mandel litigation was really up to here with all the arguments about Johnny's so bad with his money and Johnny yes. Johnny's a wreck and stuff like that. And it's funny in a black humor kind of way to look at his complaint and kind of see how it appears he's trying to pull on that image that people had of Johnny because of those types of press articles at the time. Oh, he smelled drunk. He was doing drugs all day. And right. Again, like Emma Danhoff and I think Furman as well have said like, absolutely not, that's ridiculous. Not what happened. But
I also think he waited so long to file.
Like an easy target.
Yeah, he waited so long to file that I feel he was induced by somebody. So, you have a case here. Why don't you do something? People have been talking about it.
Yeah, it's possible. It's possible.
I hope the judge is a fair one and not biased. I haven't seen anything either way with her rulings to suggest one way or the other. Can Rocky sue? Well, we just talked about whether he's going to bring a frivolous lawsuit, but hopefully Johnny just wants it done.
Yeah.
Yeah, there's more to come out from Rocky, so this will be interesting. I have some deposition sections to bring out that I think will be interesting. Yeah, another gold digger. I certainly feel like it's a cash grab. So here's been my personal opinion, and you tell me. In these kinds of cases, aren't they very common a contingency case?
That's a little bit out of my expertise. I'm gonna say probably not. Now that can vary, I think,
Interesting.
depending on where you are, kind of what your jurisdiction is like. California has a billion lawyers. They may be in a situation where competitive pressure encourages them to take things on contingency that nobody where I practice would consider taking on contingency. But the reason why contingency cases exist typically is it's in the personal injury, like automobile injury
Right.
context. And there are good cases for that because all you need to do is read the accident report and it's pretty clear if liability is established because somebody got cited a lot of the times, or just the mechanism of how the accident happened is clear. So that's a whole issue that doesn't really have to get tried most of the time. All they're really arguing about is how much the damages are. So
Right.
it's a good claim for a contingency because you're pretty sure you're going to get something. The question is just how much. With an assault and battery type of tort and disputed facts like this, liability is very much not established. And so there's a lot of costs that go into filing a lawsuit, going through the discovery in a lawsuit, preparing everything that you would need to do to go forward for trial, the actual time that you have to spend at trial. I mean, this is a big investment for the lawyer. And so they don't typically want to do that unless recovery is pretty clear. That's why I would be
Well,
surprised
they
if
probably
this was actually on contingency. But again, just depending on the environment, I can't say it's impossible.
yeah. They certainly didn't expect it to be prolonged so many times. I mean, it's
Yeah.
a 3 to 4 day trial, and that's it. And thinking it was Johnny Depp, I would have guessed that they thought they could get money thrown at them in a settlement to just make it go away based on everything that was going on in his life at the time.
Yeah, I mean, and nuisance lawsuits are common. There are what are known as deep pockets. If you're somebody who has money, if you're a company that has a lot of resources, anything like that, you can be a target for claims like this because people know you will pay them. And a lot of the times it's just much easier to pay the person a nominal amount to make them go away rather than the cost it's going to require to hire the lawyer, do all the depositions, et cetera, et cetera. So he probably could have paid Rocky Brooks off for a lot less than what this has cost him to litigate. But
Right.
the problem is that then that reaffirms this target that you have on you. It makes you look like an easy mark. And so, this may just be the point where he decided I'm done. I'm not going to tolerate this stuff, and I need to send a message that you can't just come take advantage of me.
Yeah, Adam alluded to this in one of his interviews that Amber's legal team was somehow advising or talking with Rocky's team.
Oh, interesting.
Yeah, he put that in an interview, and I think it's in some of the paperwork too. I love the discussion you guys are having. I just need to. I know Andrea has limited time, so I'm trying to get very specific questions for her. Yeah, a lot have been going on with Amber, that's for sure. How come he's bringing the suit? He 18 months before bringing the suit. On Instagram, he claimed to be Johnny's friend. Who or what persuaded him to sue? Good question. Yeah, money. Yeah, and he conveniently took that photograph down off his Facebook page, which we all found very funny in his depositions.
Yeah.
Does he have magical medical records? We're going to have fun with the deposition. I mean, you got to find humor in this stuff.
Yes, you do.
Is that the same? There you go.
Assumed risk, yeah, is exactly the same thing. It's really common with things that are inherently dangerous activities, but even in situations where it's just something like going to the gym and getting in the swimming pool. If there is a risk that is pretty well known, then it's very common for the person who is allowing you to participate in that activity to make sure you know what that risk is. And so by choosing to engage, you are assuming the risk of that harm.
I have to admit, this one gave me a giggle. Okay, I know you have to go pretty soon. Any chance he'll drop the case?
Yeah,
It's
I
been
mean,
going on a
it's
long
always
time.
possible. You don't know. I think that risk of the frivolous claim is the best leverage probably that Johnny has at this point, to try to convince him. It's more in your interest to just walk away than it is to see this thing through. A lot of that also, like Laura's pointed out, it depends on, is this a contingency case or is he having to pay out of pocket to go to trial? If he has to pay out of pocket to go to trial, he may see the light and realize, his odds aren't very good. So
Right.
stop playing the sunk cost game and cut your losses and walk away.
I think it's the 25th, July 25th, and they'll have another pre-trial conference, which they already completed that. It's really interesting. I mean, like in 2 weeks, they were going to trial and suddenly it got bumped. So they've completed.
Yeah.
There's really been no action here. There's no been additional discovery or anything like that. You have not seen he has a witness list. We will be going over the witness list and the exhibit list. Doesn't mean they're good witnesses for him. Doesn't mean they're good witnesses for Johnny, but they do have a list.
Yeah.
Thank you so much for coming on, Andrew. I know you're we went you right up to the time. I'm really hoping you come back on again because I have liminees, and I'm going to need help with those. So I will let you go.
I love motions in limine, and we didn't get to see them in the Amber Heard case. So I'm so excited we get to actually see motions in limine with this case. So I would love to.
And there's some good ones. All right, good. Thank you so much, Andrew. I appreciate it. Enjoy your weekend.
Thank you, Laura. Appreciate you having me. We'll see you soon.
Thanks. Bye-bye. Hey, I saw some great discussions about Camille, and yeah, it's awesome. Will Amber Heard and Evan Rachel Wood sue the ACLU and New York Times for all this? Will he? I guess you mean Johnny? I don't know. I'm not sure about this. So, yeah, we've been here a little over an hour. I'll probably cut this now. Thank you guys so much. I appreciate you coming. We have 1,300 here. Don't forget to like, subscribe. Appreciate your comments and share this. This will be up on the replay on my page. And I think it's a really good resource. This is an exclusive. Nobody else is covering Johnny's answer or how this all applies as far as the affirmative defenses. So I think this is really informative for a lot of people out there. I am doing this to give you the information, the community the information. So when the legacy media starts coming out with their BS as it gets closer to this case, which they will, you are now armed with more truths than they are. So you can go back and say, no, Johnny is definitely denying this happened. Just because it's an affirmative defense, he is still denying this. I think I got all of the super chats. Is every Johnny Depp case contractually required to have at least one Rocky? It would seem so, right? Because TMG just was out there to smear him, Bloom, his bodyguards. They're all money grabs. And Amber, she was just doing for a political advocacy, victimhood career because she's not a good actress. I mean, we heard that from Hamada. She's just not a good actress. There was no chemistry there, and they had to manipulate and edit scenes to create something that didn't exist. So it seems like that. I think I got all the super chats. I don't see any else that I'm missing. And I so appreciate you guys coming. I got these. Yes, I got those. So the next one is going to be some more. You'll see. You'll see. I'm going to try and do a week up roundup, but boy, there's been so much. I'm not sure I have time. By the way, I have a new grandbaby coming Friday. It's planned. She's having a cesarean from prior issues. So I'm going to do the best I can to keep posting. I made up a few for this case that I can post in a couple days to keep us covered for the next week or so. And then I'm going to have Andrea back to do these limines, which are what's admissible and what isn't. So I am going to thank you all for being here, and I'm going to go bye-byes. Thanks, guys. Have a good day.